So the Supreme Court will hear the next major Second Amendment case, and it will happen this November. So let's talk about this. But real quick before we jump into this video, I want to ask you all a favor. I was looking at some of my analytics and I saw that only a small percentage of all my subscribers and viewers actually have notifications on. And the notifications, if you go next to the subscribe button and you click the bell icon and you click on all notifications, that actually helps you to get notifications for all these videos that I put out. As you're aware, sometimes media doesn't like this type of information get out, and those notification bells and all notifications actually helps you to get my videos when otherwise maybe it wouldn't be sent to you. So again, if you could do that, turn on all notifications, that really does help the channel and what we're doing here on these videos. So as I mentioned in the intro, in this video, we will be discussing an important Second Amendment case, which was granted review by the Supreme Court and is now set to have oral arguments this November. That means that the Supreme Court will hear and rule on a new Second Amendment case before the end of their next term. The case we're going to be talking about and the case that they are hearing is called U.S. v. Rahimi. In this case, the government were actually the ones who sought Supreme Court review because the Fifth Circuit recently ruled that the federal prohibition on gun possession for people subject to domestic violence restraining orders is in fact unconstitutional under the Second Amendment. In that critical decision by the Fifth Circuit 3-judge panel analyzed the federal law, which is 18 U.S.C. section 922G8, and they analyzed it under the Supreme Court's recent decision in New York State Rifle and Pistol Association versus Bruin. Bruin requires that a government's restriction on the right to keep and bear arms must have a historical basis or analog that dates back to 1791. If it does not, then the law must be struck down as unconstitutional. The Supreme Court has now granted review to this case and will decide if they want to strike down this federal law prohibiting the possession of firearms for anyone subject to a domestic violence restraining order under that federal law. This decision has huge implications for other cases because we will get further clarification from the Supreme Court on how the Bruin analysis should be applied going forward. This will help to prevent a situation where lower courts will misapply Bruin in that type of analysis like they did after the Heller decision. And also, one of the really interesting things about this case is the Supreme Court will look at who are the people as the text of the Second Amendment mentions. Now, the facts around this case are not great, and I want to state from the outset that Mr. Rahimi is not a good person, and he should have been charged and convicted under other things. So between December of 2020 and January 2021, Mr. Rahimi was involved in 5 shootings in and around the Arlington, Texas area. On December 1st, after selling narcotics to an individual, he fired multiple shots into that individual's residence. The following day, Mr. Rahimi was involved in a car accident, and then the reports are that he exited the vehicle and then shot at the other driver. He then fled the scene and later came back in a new vehicle and then once again shot at that driver's car. Then on January 7th, Mr. Rahimi fired multiple shots in a Whataburger restaurant when his friend's credit card was declined. The officers in that Arlington area identified that the individual, the suspect, was Mr. Rahimi, that he was was involved in multiple shootings, that he shot in the Whataburger, and then they got a warrant. It was served at his house and at his home. Multiple rifles and pistols were found at the location, and Mr. Rahimi admitted that those were his firearms and that he was in possession of them. He also admitted that he was subject to a civil protection order, and that was in February 2020. And the protective order essentially restrained him from harassing, stalking, and threatening his ex-girlfriend and their child. The order also expressly prohibited Mr. Rahimi from possessing any firearms. Now, as a result of him being in possession of firearms, a federal grand jury indicted Mr. Rahimi for possessing a firearm while under a domestic violence restraining order in violation of federal law 18 U.S.C. section 922G8, and that is the piece of federal law which is in question in this case. Early in his case, he brought a challenge against that aspect of the federal law. He challenged it as unconstitutional under the Second Amendment. However, he lost that argument since prior Fifth Circuit precedent found under the interest balancing approach that piece of federal law was in fact constitutional. He then appealed that decision up to the Fifth Circuit, who again found that type of argument was foreclosed because of their prior precedent. But then the Supreme Court issued their 6-3 decision in Bruin, which reaffirmed that text, as informed by history and tradition, is the proper type of analysis, not interest balancing. So that Fifth Circuit precedent was then essentially struck down, was overruled, and the Fifth Circuit panel then withdrew their prior opinion and then reanalyzed the decision here in the Rahimi case and ruled that under Bruin, their prior precedent was no longer valid, and that this piece of federal law prohibiting firearms and ammunition possession for those who are subject to a domestic violence restraining order is in fact a violation of the Second Amendment. In reaching their decision, the Fifth Circuit panel stated that the government fails to demonstrate that section 922G8's restriction of the Second Amendment right fits within our nation's historical tradition of firearms regulations. The government's proffered analogs falter under one or both of the metrics the Supreme Court articulated in Bruin as the baseline for measuring relevantly similar analogs. How and why the regulations burden a law-abiding citizen's right to armed self-defense. As a result, Section 922G8 falls outside the class of firearms regulations countenanced by the Second Amendment. Based on this, the Fifth Circuit found that this section of federal gun control is unconstitutional and vacated Mr. Rahimi's conviction of possessing a firearm in violation of that law. Obviously, this wouldn't sit well with the government. It didn't sit well with the anti-gun side. So, in fact, what they decided to do is go up to the Supreme Court to bypass en banc panel review in the Fifth Circuit and just simply ask for the Supreme Court to review this case. And then at the end of the Supreme Court's last term, we received some cleanup orders and news that the Supreme Court did in fact grant review of this case. This was significant not just for the application of 922G8 and that challenge to that aspect of federal law, but it also has broader implications. The decision of the court will have to apply the Bruin analysis against 922G8, and that means we will get further language on when gun control laws like this one meet the text and history standard, which was set out in Bruin, and essentially when they do not. Also, this case and this decision will essentially center around who are the people as mentioned in the text of the Second Amendment, which is significant. Now, we just received news that the Supreme Court has set oral arguments in this Rahimi case, which will now take place on November 7th of 2023. So in just a couple months, the Supreme Court will hear oral arguments on the constitutionality of 922G8 and what impacts Bruin has on this aspect of federal law. I know that many of you probably have never followed Supreme Court oral arguments or maybe never even listened to them. The arguments can be listened to live quite often. Maybe if you were following the channel back when the Bruin oral arguments took place, you know that we held live kind of analysis of that. I had it here on the channel. We live streamed that. So maybe if you're interested in that, we can do that again here on the channel where we'll live stream the Rahimi arguments. Again, if you guys would like that, let me know down in the comment section and we can do that for sure. Typically during the arguments, if you're not aware, you will have both sides present statements, oftentimes about like 30 minutes. Each side gets a specific set of number of time. And then often the petitioners will get some rebuttal time if they decide to reserve time. Also, for the arguments, expect a lot of hypothetical questions to be asked by the justices. I know a lot of people who are not familiar with oral arguments, sometimes they get thrown off by the judges and how they're often interrupting the attorneys for the parties and asking them these strange hypotheticals. The reason the justices are doing that is to test the strength of each party's arguments and to test how far their logic can actually be stretched. So they're kind of just testing the outer bounds of these arguments and seeing maybe where there are holes and where there aren't. But for me, one of the big things and the big things that I'm gonna be watching for in the oral arguments is the demeanor and the questions which are being asked by Justices Kavanaugh, Barrett, and then Roberts. Kavanaugh and Barrett can be wild cards. Barrett, especially recently, many of you are familiar that recently Justice Barrett and Roberts joined the liberals in siding with the ATF when the ATF went to the Supreme Court and asked for the Supreme Court to grant a stay which protected the pistol brace rule. Barrett and Roberts joined the liberals in granting the ATF stay. So it's going to be interesting to see maybe the demeanor of Barrett, what type of questions she asked, what type of questions Kavanaugh is asking, and then just generally what the whole kind of panel of justices are asking. But the ones I'm really going to be focusing on are Barrett and Kavanaugh because to me, they tend to be the wild card. Roberts also is always a wild card, but really Barrett now has a lot of question marks around her. And so I think Rahimi in this oral argument will help to answer some of those questions. So this is going to be a really interesting case. I have some hesitation with this case. Obviously, I don't think it's a perfect case and I would have hoped for better facts and arguments and a better plaintiff, but right now, that's kind of what we're stuck with. This case is up for Supreme Court review. It's scheduled for arguments on November 7th, and all we can do is prepare to listen to arguments. And again, if you want to listen live with me, if you want me to do a live stream, let me know in the comment section, and we can definitely do that. But if you guys like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. As always, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.